interpretation. This is the material for week 9, and we're dealing with traditional common law approaches. What we're dealing with this week is often used as the material for week 1 in other units that or other courses dealing with statutory interpretation. And it was certainly the case when I was introduced to law many years ago, where we were taken through the common law approaches as the appropriate means of interpreting legislation. Now, by that I mean there are some ways that the common law has been incorporated into our legislation, particularly our Acts Interpretation Act. There are some common themes that follow through in some of the sections of that legislation. For example, when we talk about interpreting legislation so that we're considering the object or we're considering the mischief, it's really a reference to the mischief rule. If we're considering an interpretation of legislation by reference to whether it is logical and it's and probative and it makes sense within the context of the purpose, we're really talking about a purposive approach to legislation. So a lot of these things have their genesis in common law, and the common law is still very much important to interpretation of legislation. But the reason I like to teach it now rather than at the start is so that it is clear, as I've mentioned, I think in week 1, that you must always consider the legislation first and then the common law after that, in my view. Now, there are some valuable resources available to you. Obviously, your text is an extremely valuable resource when considering traditional common law approaches. I've mentioned previously, and I do hope that you've considered, the Queensland Legislation Handbook. And I'll share the screen now so that we can look at that once again. I do hope that you're now looking at the Queensland Legislation Handbook. It's designed by the Office of Queensland Parliamentary Counsel. It explains some of the background information used by those who draft legislation in coming to determine suitable legislation. It's designed primarily for use by policy or instructing officers to help them work with the Queensland Parliamentary Council. So why is it relevant to you in studying law, and why is it relevant to you more particularly in studying statutory interpretation? Well, it provides valuable resource for a number of reasons. The first is, given that it's relied upon by those who draft legislation, you'd think it would be a valuable resource to you if you want to understand the policy and the means of drafting legislation that you're trying to interpret. It provides some excellent commentary generally. So, for example, Chapter 1, Context of Legislation. Now, if you just read that heading of itself, think, well, that is really important to read, because almost everything that I do within the context of statutory interpretation refers me to the purpose or the objects of the legislation or the context within which that legislation is drafted. So in drafting legislation, legislation has an interplay with the general law or the common law, as we call it. So 1.1 gives you an idea of traditional common law approaches because it refers to the general law. Now, the general law to me says essentially the common law. Number 1.2 is also a very interesting heading because it says, why is legislation needed? Now, that has a link to traditional common law approaches because it suggests to me that some commentary about the mischief that's sought to be addressed with the introduction of legislation is relevant to the question as to why legislation is needed. It also talks about the mischief approach, which is one of the traditional common law approaches to statutory interpretation. How legislation operates is also useful. Then, when we look at Chapter 2, it talks about policy development. And 2.2, again, is a very interesting heading because it says, is the new law needed? So when we're talking about the use of extrinsic materials, as we did last week, the question of is a law needed is essentially addressed in those extrinsic materials. So that's a very interesting heading as well. Now, further in Chapter 2, you will see that there's some excellent commentary about the way in which the laws come into existence generally through the issue of sponsoring a bill, the distinction between a bill and subordinate legislation, which is very important. And 2.10, 2.11, 2.12 are really very important because they bring together a number of things that you need to be mindful of in interpreting legislation. So, for example, in 2.10, there's the heading Considering Fundamental Legislative Principles. In other words, drafting legislation is not done in a vacuum. The drafting of legislation is done within the context of other legislation, such as the Acts Interpretation Act, but also the traditional common law approaches and, which we'll deal with next week, statutory presumptions. So these things are very important within the context of putting together a government bill. So Chapter 2, dealing with policy development of a government bill, contains some really important principles to do with statutory interpretation. Now, Chapter 3 deals with the drafting process. Again, very valuable. Chapter 4, the parliamentary process. If you're unsure about how this works in practice, I'd commend Chapter 4 to you. Now, some of the interesting things there specifically to statutory interpretation. 4.3 deals with explanatory notes, which, as we know, is one of the key forms of extrinsic material for you to consider. 4.9 deals specifically with second reading speeches. Again, very important material. And we've talked about previously the importance of considering the record of proceedings. 4.13 deals with that issue specifically. Now, an overriding consideration in the current climate is human rights. We have now the Human Rights Act in Queensland. Read legislation within the context of human rights. This is really a week 11 topic, but look at 4.5, which talks about human rights and the need for a statement of compatibility with human rights, which brings together other extrinsic materials such as treaties and other Commonwealth legislation, for example. Chapter 5 deals with the issue of royal assent, and as we know, a common issue to be mindful of in interpreting legislation is, when does the legislation take effect? And that means we need to consider the issue of royal assent. Now, Chapter 6 is really important in a practical sense, a matter that I haven't dealt with in much detail, but it is important from a practical sense because it deals with subordinate legislation. Now, the fact is that legislation that we see as such represents the very cream, the important parts of our legislation, but probably in terms of outright number, there's more subordinate legislation than there is legislation. So subordinate legislation is important in a very practical sense because it provides for the means of making laws in an easier, more pliable fashion so that legislative type powers are conferred on others so that they may make subordinate legislation to supplement or to deal with issues that are not dealt with directly by legislation. It's much easier to change subordinate legislation than it is to change legislation. So do have a look at that section. And again, we see 6.11 explanatory notes. That's really always got to be an important part of these sorts of issues. And sections 6.5 and 6.6 are important because whilst the Queensland Parliamentary Council is responsible for drafting government bills and most subordinate legislation in Queensland, it doesn't deal with all of it, but there are some important principles. For example, general presumption that legislation will be prospective rather than retrospective, and the issue of retrospective operation, but only of a beneficial provision. 6.5, 6.6 are potentially important because it's often the case in statutory interpretation problems that to some degree you need to consider whether the problem relates to a prospective or retrospective scenario. So have a look at those notes. It'll provide you with a great deal of information. And also look at fundamental legislative principles. Now, this almost directly relates to the week 10 work, but it also deals with some of the common law approaches that we're dealing with this week. And part 8, chapter 8, dealing with human rights, deals very much with the week 11 material. So the legislative handbook is a particularly valuable source of information relevant to you in statutory interpretation. So I once again commend that to you. And you'll see, for example, another, and I've just removed it from the screen, but there's an area of 2.11.16 that deals with the liability of directors for corporations' offences. So it's possible for legislation to render individuals, directors, liable for corporate sins and offences. So do look at that also. All right, so when it comes to the common law approach to statutory interpretation, there are a few types of techniques that were used traditionally that you'll read about often. So the first, the most basic, is the literal rule. The next is the golden rule, then we have the mischief rules. So the literal rule, as the name implies, means that when you're looking to interpret legislation, you look at it and interpret it literally, irrespective of whether that creates an absurd or unreasonable or perhaps unintended result, but you read it as it is. That's the literal rule. The golden rule is a little different in that we can then consider whether those absurdities and inconsistencies might favour an alternative, perhaps more reasonable approach. The mischief rule is one where we're interpreting legislation specifically by reference to that which the legislation is designed to remedy. What's the mischief? And therefore, when we're reading the legislation, we have to refer it back to the mischief, which is really referring it back to the intent for the legislation to come into existence. So one of the key issues that you need to bear in mind if you're going to attempt to answer a question based on one of the common law approaches is this. The doctrine of parliamentary sovereignty applies. What that means in simple terms is that a statute prevails over the common law unless there's some issue about constitution issues. And that's why I teach this subject in what might be regarded as the reverse order traditionally, although Michelle Sanson produces her book in the same way that I'm advancing to you now. And that is, always consider the statute first, then consider the common law exceptions within the context of interpreting the legislation, but be reluctant to advance a direct argument based on statutory interpretation by reference to, for example, the Golden Rule, as opposed to the Acts Interpretation Act. But you must always consider the constitutional elements as well. And in Jaeger against the Crown, 1977, 139 CLR 28, the High Court confirmed that the construction, which is another word for the interpretation of a statute, is a question of law. Therefore, issues of statutory interpretation arising in the context of a jury trial, it's for the judge to decide the connotation a word should be given, rather than left initially to the jury for that purpose. Have a look at figure 9.1 in your text. It provides a good means of dealing with the interaction between the common law and statute in the development of law. So when you're reading that figure, note that the bottom is past and the top is present. So, for example, where an area of law developed over time at common law, but now there's a statute on that topic, the statute may build on the common law through codifying it or extending its operation in some way, or it may replace the common law. So this has consequences for statutory interpretation because it affects the degree to which the prior common law may be useful in interpreting the legislation. So the common law has a place to play in the scenarios that are in your textbook, with the exception of the second scenario where the statute purports to cover the field and replace the common law. So you need to consider that within the context of answering legal problems based on this. Now, one of the common law principles is the use of analogy in interpretation. So, for example, in your text, scenario D deals with where the common law is developed through reasoning by analogy to statutory principles. Have a look at the decision of RVL 1991 175 CLR 379 in that regard. All right, so traditional statutory interpretation approaches at common law were the literal rule, the golden rule, and the mischief rule. When you're considering using those, do so within the context of ensuring that you read the Acts Interpretation Act, either Commonwealth or state, first, before necessarily considering implementing any of those common law approaches. Now, before we wrap up for this week in this session, I'd just like to commend to you a resource that I've found to be very valuable over an extended period, and it's called Interpretation Now. It's actually through the Australian Taxation Office, which is a bit odd, but you can access Interpretation Now through the ATO legal database, and it's a regular publication. And what it does is summarise relevant authorities applying to the rules of statutory interpretation. You can subscribe to updates, which I'd recommend you consider. And look, some of the examples of the material that you might find of interest, for example, in the March 2018 publication, there's some discussion and reference to case law regarding the words may and must. And even though we tend to think of those words as mutually exclusive, may meaning prerogative to do so, but not required to do so, must meaning there's no prerogative, there's a mandatory requirement. In that article, the authors talk about how the word may can sometimes mean must. Have a look at the article to get a broader understanding of how that means. December 2017 talks about the meaning of a proceeding. And in April 2018, there's commentary about court orders being construed in the same way as contracts. So there's a lot of really good material there in the ATO legal database called Interpretation Now. All right, keep up the good work. Read all about the common law, but do so carefully and don't let it override your commentary in interpretation of statutes.